All right, good afternoon, everybody. We entered that realm. Um, as you heard, our webinar today is being recorded, and but only the presenters will be recorded. And I'll go over just a few housekeeping items. I'm Ben Dunlap. I'm managing partner here at Nauman Smith and do a lot of business and employment work in addition to the railroad work that some of you on today know me for. And as far as the other housekeeping items, you're welcome to turn your videos on if you'd like. And in that case, we could see your faces and reactions to the content, but that's your choice. We do ask that everyone remain on mute during the presentation. Now, at the end, we will provide 5 minutes for questions, and you can ask them live at that time. Unmute yourself. Or if you'd like, if you're the type like me who needs to get things out when they think of them or they forget them, you can put them in the chat room and then I'll ask them at the end. And finally, after the presentation today, you'll receive a link to the day's recording along with contact information. So you can watch it again or send it on to other people who you, colleagues and so forth, who you think might be benefited by the information that's going to be conveyed. And at this time, I have the distinct pleasure of introducing our associate, Jennifer Bruce, who goes by Jenny, as you can see. And Jenny joined our firm full-time about a year ago, and before that was a law clerk here, and for a prior year or so. And Jenny works in our business and employment group, doing a lot of the same work that I do along with me. And she's been a great help since she's been here. She has worked on an array of business matters, particularly on some in the employment realm, on some discrimination and termination matters that she's handled quite adeptly. And in her background, Jenny is an undergrad, received her undergrad degree from Fairleigh Dickinson University and her law degree from Penn State Law, where she graduated summa cum laude and received the International Academy of Trial Lawyers Award at graduation. And she had quite a distinction while she was at law school, in that she was a member of the Civil Rights Appellate Clinic and did something that many attorneys who have practiced for many years have not done yet, and that is that she successfully argued a case before the Third Circuit Court of Appeals. Jenny, also at law school, was inducted in the Woolsack Honor Society and completed concentrations in labor and employment law and constitutional and civil rights. And most of the presentation today is going to be presented by Jenny, and I'll chime in here and there with some personal experiences from my years in the practice. And as I mentioned, at the end, we'll have 5 minutes for questions. Okay, take it away, Jenny.
Thanks for the introduction, Ben, and good afternoon, everybody. Thanks for joining us. I'm excited to be here. Since we have a short webinar today, I'm just going to jump right into our topic and begin the discussion on the pros and cons of choosing arbitration or litigation. But before we evaluate the benefits of each, we do need to think about what arbitration looks like in the workplace. Arbitration is a way to resolve your disputes out of court. You have a form, arbitration is a form of dispute resolution. It's called ADR. You have a neutral decision maker, referred to as an arbitrator, sometimes a panel. It's often a retired judge who renders a decision to end your dispute. The process is much more flexible than the litigation process and is usually more open for negotiation. It's different from mediation because usually a mediator meets with the parties and brainstorms solutions and comes to the parties more to bring the parties together, where the arbitrator is making a decision on your dispute. It's also different from a grievance process you may have in your company, because a grievance procedure is a process designed by the employer or by the employer with the union for the worker to use or resolve their dispute internally, usually by speaking with a human resources department or through some type of internal investigation procedure. So when we're talking about arbitration, there's usually two main types, binding or non-binding. Binding arbitration is where the parties waive the right to a trial and they agree they will be bound by the arbitrator's final decision. Non-binding arbitration is the type of arbitration where the arbitrator makes a decision on the outcome of the dispute, but this decision is non-binding and no enforceable award is made. So in this kind, each party can reject the decision and still request a formal trial. You may be wondering why somebody would want to choose this kind of arbitration if you could still end up in trial. This may be beneficial if you would like to have a non-biased third party assess the strengths and weaknesses of your case. If you think you may end up in litigation, it also may keep the positive working relationship between the employee and employer because it's not a complete conflict in the situation. And it's also more useful maybe in a less complex situation where the parties just want some guidance on their positions. And finally, in the employment context, you're probably going to see the arbitration agreement arise in a clause in the employment contract. So moving to litigation. Litigation is when you bring a case to court to resolve your dispute, typically by filing a complaint. It's the entire legal process where the parties argue against each other through the court system. So you have a jury or a judge making the final decision for the parties, unless you settle your case before trial. And with litigation, you have multiple layers of appeals that could arise, either during the case or after the decision is made. So it's a much longer process. Typically, arbitration agreements in the workplace take the shape of mandatory arbitration. That's when an employer asks the employee to sign the arbitration agreement, usually in a clause in an employee contract, asking the employee to give up their right to sue in court over job-related claims such as breach of contract, wrongful termination, discrimination. And this is going to depend on the language of the arbitration clause. And once they agree to this, the employee must then pursue any claim against the employer through arbitration. Keep in mind, there is also compulsory arbitration that is different from these kinds of contractual agreements we're discussing. Compulsory arbitration is mandated by court rules. In some instances, if the damages that are alleged in a civil suit are less than what the court ordered arbitration limits are, the court will send the case to compulsory arbitration first. Oh. Lost my light there for a minute. The compulsory arbitration limit in Dauphin County, I believe, is $50,000. It is also interesting to consider how prevalent arbitration is, mandatory arbitration is here in Pennsylvania before you weigh the pros and cons of choosing arbitration in your own agreements. We looked up some statistics here in Pennsylvania, and it seems across the board, even for smaller employers, mandatory arbitration is being used about 50% of the time. And this was pretty consistent with the rates across the country. Ben, is this what you have been seeing in your contracts that you review?
Well, actually, in the employment agreements that I review, I found this statistic really interesting because I have actually, outside of the collective bargaining realm, I have never seen an arbitration provision in an employment agreement, be it a non-compete or an actual outright employment agreement that we think of where it talks about pays and reasons for termination, where you would think that I would think that I would see some of them crop up with these kind of statistics. And where I've seen them over the years are mainly like in vendor contracts, clients who have IT contracts or other business vendor agreements or other business relationships. They can be fairly common. For instance, I had an arbitration some years ago with two parties, and there was a dispute about how payments were to be calculated, and it went to arbitration. It was a 3-day arbitration, and it ended up in a $1 billion plus win for our client. So that's where I see them more often, Jenny.
And I would be interested to see how these numbers change after the upcoming legislation and the recent legislation that I'm going to discuss in a little bit as well. So moving into balancing the pros and cons of choosing arbitration over litigation for workplace disputes, it is important to remember that whether arbitration is beneficial for your situation is going to depend on the types of disputes that generally come up and the makeup of your workforce. But there are some general pros and cons that we can consider. The first benefit and the most cited benefit of choosing arbitration over litigation is the speed of the process, and in return, the cost savings for both parties. In most cases, arbitration is going to be much shorter than litigation. The American Arbitration Association estimates that cases go through the U.S. district courts on average 12 months longer just to get to trial than it takes to adjudicate by arbitration. And that process is 21 months longer if you include the appeals process. So both parties are seeing significant cost savings by choosing arbitration for workplace disputes. Another pro is the informality of arbitration. Parties are often encouraged to participate fully and work together in the arbitration process. We also see privacy in the arbitration process as a big pro. The results in arbitration are not part of the public record, and the parties can also agree to keep the terms of any final resolutions confidential. That's also something I'm going to discuss a little later in legislation. Another positive aspect of arbitration is the flexibility. In litigation, the parties are usually at the mercy of the court hearing schedule, but arbitration hearings can be scheduled around the calendars of those involved. And with COVID, court scheduling has been delayed, so arbitration, maybe that's an increased pro lately. The cost of arbitration is definitely another pro. Arbitration is often seen as far less costly than using litigation. The process is much quicker and less complicated than going to court. Arbitration also doesn't have the numerous layers of appeals and the extensive discovery, which means less attorney's fees. And you can make decisions on the proceedings and the process in advance through the use of your arbitration agreement. So that can also cut down on the cost. Arbitration decisions are also more final. So there's more limited opportunities for appeal once the arbitrator makes their decision. This is beneficial for employer and employee to know once a decision has been made that ends the dispute. On damages, that's also seen as a pro, probably more for the employer. Arbitrators do have the power to award things like punitive damages, but the parties can exclude these types of awards in their arbitration agreement. Class action waivers. These are provisions within the arbitration agreement that state an employee agrees to resolve the employment dispute on an individual basis and agrees to refrain from joining a class action. Back in 2018, in a case called Epic Systems, the Supreme Court confirmed the validity of these class action waivers. And that's another way that you can use arbitration agreements to limit exposure. And finally, the fact that you do not have a jury making a decision is often seen as another pro for using arbitration agreements in the workplace. Jury decisions can often be unpredictable, although arbitrators are people too, so they could be sympathetic or unpredictable, so keep that in mind. Taking a pause here, Ben, you have experience litigating and arbitrating different types of workplace disputes. Would you say these pros are in line with what you have seen?
Yes, in litigation broadly, I've experienced personally all of those pros with the exception of class action waiver. It's in all the arbitrations that I've been involved in, it's definitely been faster than a court proceeding. The finality is good because you don't have to worry about it going on and through the appeals process. And, depending upon the nature of the matter at stake, in a lot of business matters, employers don't want to have things out in the public. And Jenny will get into that in some discrimination cases. But yes, I've seen almost all of those pros.
And moving on to the downside of selecting arbitration, starting with the lack of a formal evidence process. When we go to court, we are bound by formal rules of evidence. but in arbitration, you're relying on the skill and experience of the arbitrator to sort through the evidence rather than a judge or a jury. There's a more simplified discovery process in arbitration. This could be seen as a pro or a con. In arbitration, you have less discovery than litigation, meaning there may be no interrogatories or depositions. The Pennsylvania rules allow arbitrators broad discovery powers, so they can order discovery in appropriate circumstances when they deem it necessary. They can issue subpoenas, order depositions upon request for both party and non-party witnesses, depending on the case. So you're going to see it vary depending on the situation. It's a pro for the cost savings, but it could be seen as a con because there is less information being exchanged than in litigation. Another con is that there's no or limited rights to appeal. It's very difficult to appeal an arbitration ruling, even if the arbitrator did make a mistake. The flip side on this time savings is that while the overall dispute may be resolved faster, there are no legal motions in advance to trial to narrow the issues or dismiss some of the claims, like you would have a motion for summary judgment at trial. Of course, you can settle anytime before the arbitrator issues an award. And another side of the cost savings is there are fees associated with the arbitrator's time. So there's fees for activities like conferences, reviewing briefs, having hearings, issuing orders. So there are still costs associated with arbitration. Ben, would you agree with these downsides to selecting arbitration in your experience?
Yes, and some of them, some of the pros like finality can be a con too. In that, as Jenny said, it's very hard to appeal an arbitration award, even if you feel that the arbitrator made a mistake. It's really bad faith is basically the only basis on which you can appeal an arbitration award, and so that makes the decision of what arbitrator is chosen really key. If you are going to go the arbitration route, time should definitely be spent to look into the arbitrators, whether it's through JAMS or American Arbitration Association or so forth. And the nice thing is, though, that you get a say in who the arbitrator is. That in most of them that I've done, where sometimes you can agree with the other side on an arbitrator, and that's happened in several of them that I've been involved in. But also, if not, and you're going through AAA, you may get 10, they may send you 10 possible arbitrators, and you pick your top 3, and the other side picks their top 3, and you see where they coalesce. And so you get to, some ability to choose who's going to be deciding the case, whereas you can't really choose a judge. Generally, unless you're suing an accounting where they only have 1 or 2 judges, and then there's some chance there. And I recently had a case where the other side in negotiations on a vendor contract, the other side was insistent that you have 3 arbitrators, and to me that defeats the whole purpose, because in that when you have one that our side would choose, one the other side would choose, and then a neutral that would be chosen by, say, the other 2, and that just increases costs, and to me, I don't understand that. And the final thing that I think is a con, would be the class action waivers. When they're enforced, that can be really unfair to somebody who has limited means. For instance, if I'm not mistaken, the Epic case had to do with credit card fees, and there, a retailer may just have, a couple $100 worth of losses. Well, they can't, hire an attorney for that. They need to, join together. So there is some, dispute there.
Great point. So when we're weighing the benefits of arbitration, there are some new and upcoming legislation that may impact what you decide to adopt as an employer. and if you're subject to an arbitration clause, how you choose to proceed. So starting with the FAIR Act, it's called the Forced Arbitration Injustice Repeal Act of this year. It's a bill that would void all pre-dispute mandatory arbitration agreements in employment, antitrust, consumer, and civil rights disputes, and it would prohibit the class action waivers we were just talking about. It was passed in the US House on March 17th of this year. It's not clear that the FAIR Act will become law because it does not have bipartisan support in the Senate. The bill is also a large departure from the body of Supreme Court precedent interpreting the Federal Arbitration Act, which allows parties to have these pre-dispute arbitration agreements. But the FAIR Act would be retroactive, meaning that it would invalidate prior agreements. So it is something to keep an eye on going forward. There's also been some activity in the area of confidentiality clauses. Typically, an arbitration agreement is accompanied by a provision that the proceedings will remain confidential and sealed between the parties. January 18th of this past year, the National Labor Relations Board announced that it is considering adopting a new legal standard for whether confidentiality requirements in mandatory arbitration agreements would violate the National Labor Relations Act in a case called Ralph's Grocery. Keep in mind that most employees in the private sector are covered under the National Labor Relations Act, so this ruling would apply to both union and non-union companies. So employers that utilize mandatory arbitration clauses should monitor this issue. This is something that will develop in the upcoming year. And finally, on the sexual harassment and sexual assault claims, March 3rd, the Ending Forced Arbitration and Sexual Assault and Sexual Harassment Act of 2021 was signed into law. This is often called the Me Too law in the arbitration space. It's the consequence of the Me Too movement that began back in 2017, 2018. The act amends the Federal Arbitration Act to prohibit the enforcement of pre-dispute agreements mandating arbitration for sexual assault and sexual harassment claims. So going forward, any claims arising after March 3rd, employees have the option to reject arbitration agreements and bring their claims in court or via class action. So now it's the employee's choice to arbitrate. So the act prohibits pre-dispute arbitration, but the employer still can provide the option for arbitration of these sexual harassment claims once the dispute arises. And keep in mind, in a sexual harassment claim, typically an administrative charge would be filed. So the dialogue between the employee and the employer has probably already opened up. So there is going to be an option to offer the arbitration process at some point during that time. It's also important to look at your existing arbitration clauses given this legislation. The law does not invalidate mandatory arbitration clauses entirely, but employers may want to amend existing pre-dispute arbitration agreements to exclude cases related to sexual assault and harassment to avoid uncertainty. Employers may also want to consider arbitration agreements to address how and when an employee will elect the arbitration in the process. And it's also not a good idea to ask employees to waive the rights in this new Me Too law in any mandatory arbitration agreements going forward. And overall, given all of these recent changes and potential upcoming changes in the regulatory scheme, you may want to reconsider how you weigh the pros and cons of choosing arbitration in your workplace. And finally, looking forward to the rest of 2022, we know there's some litigation trends to keep an eye on, and this can also help us inform whether we choose to use arbitration to resolve our disputes. Balancing the pros and cons of arbitration, of course, will be unique given how the pandemic has changed our workforce. Also, if we see a blanket ban on mandatory arbitration from the FAIR Act, we're going to have to conduct case-by-case analysis more often. There are 3 areas of litigation to think about when you're considering arbitration this year. The first area is non-compete disputes. You may see arbitration agreements or arbitration clauses in your non-compete clauses or non-compete agreements. We have seen unprecedented employee movement this year, and on the backside of that, there's been increased litigation over non-competes. And the pros and cons for using a arbitration agreement for a non-compete dispute would be similar to what we discussed earlier, but there is an additional pro to using that here. In non-compete disputes, jurisdictions usually have widely varying tests on the validity of the non-compete, and an arbitration clause would provide more certainty about the law and the forum of where, how the non-compete would be tested for that validity. So that's a pro for the employer and for the employee signing the non-compete agreement. Employers have also been faced with an increased demand for remote work and vaccine policies. Arbitration may be more cost-effective and faster to handle these disputes. But remember that many of these claims fall under the ADA, and employees can still file discrimination charges with the EEOC regardless of an arbitration clause. So that's something to keep in mind when weighing the pros and cons. And finally, we have seen some novel wage and hour claims emerge in the past year from employers' pandemic efforts and the continued use of remote work. There's been some different types of off-the-clock scenarios that have come up, such as claims for compensation for computer boot up times. There have also been class actions for time spent in COVID temperature screening. And in the past, the Supreme Court has upheld the use of arbitration even when Fair Labor Standards Act claims are involved. And given the fact that you can use the class action waiver like we discussed, this may be something to consider in the upcoming year.
All right, thank you, Jenny. I don't see any questions in the chat room, but we have a few minutes left if anyone has any questions. So you are welcome to unmute yourself and ask away. All right, Jenny, you want to close it out?
Yeah, well, thank you all for joining us this afternoon for our discussion on arbitration and litigation. If you have any questions that come up later and we weren't able to address it through the webinar, or if this webinar has sparked any interest for you on any additional topics in arbitration, feel free to get in contact with either me or Ben through the contact information that Sarah is going to be sending to you after our program. And have a great rest of your day.